Hello, everyone. Welcome back to SEC Roundup. My name is Tom Zaccaro. I'm a board member with ICANN. And with me today is, as always, Nick Morgan, the founder and president of ICANN. Hey, Nick.
Tom, so nice to see you. Thanks for doing this.
Nice to see you, too. We're delighted to have a very special guest today, Lori Echavarria. We've both known Lori for many years since we were all at the commission together. Lori was at the commission for 15 years, left as the associate director of the LA regional office, and for the last 10 years has been a partner at WilmerHale. Hey, Lori, great to see you again.
Great to see you both. Thank you for having me on. Happy to talk with you today.
So our topic today is something that, Lori, I know you're going to be very familiar with, which is the SEC's recently released enforcement manual, a document that hasn't been refreshed in 10 years and was long anticipated to show and reflect Chairman Atkins' view of SEC enforcement. So, Nick, let me start with you. Maybe you can just describe what the enforcement manual is and what it's intended to do.
Absolutely. So just to give away how old I am, I will describe the enforcement manual. When it was handed to me on my first day at the SEC, it was a plastic, flimsy, red 3-ring binder, 50 to 75 pages long. And it was basically, for a new enforcement attorney, kind of a user manual. Hey, you want to know what a formal order is? Go in here and you can look it up. And really that's what it is. Now, obviously it's digital, it's available to the public, which I think many people unfamiliar with the SEC might find it sort of illuminating if they cared about how enforcement investigations and litigation are conducted. So it's basically meant to be an internal user's manual for enforcement lawyers. But I do find it interesting. There's been a lot written about this revision, and we'll hear about some of the changes from Lori, but you hear things like new manual codifies changes. Well, it's not that. This is not rules. The SEC has rules they can put out. It's not statutory. It's not rules of practice. So there are a lot of things that it is not, but it's a good resource for enforcement attorneys and for people who are sort of generally curious about how an enforcement investigation and the different nooks and crannies and terms of art and acronyms and things that get used in an investigation. It's a good place to find that out. And it's a nice place for the commission and the new director of enforcement to sort of lay out the way they would like to see investigations and litigation run. And that's why I think people are paying attention to it, because the SEC's out there investigating things.
So, Lori, how significant is this? Is it a release of this new enforcement manual?
So I do think it is a good bellwether for kind of how the new and current director of the enforcement division, Judge Meg Ryan, and how Chairman Paul Atkins, who's new-ish chairman of the commission, think about how they want the Division of Enforcement to conduct investigations. I think it is significant in that way. It gives you an idea of how they're thinking about the proper mechanisms and considerations for the staff to take in to think about when they are conducting investigations. But I think what Nick said is really also important. It isn't binding on the commission or on the staff. You can't go to court and enforce anything that's in the enforcement manual. So these are things that basically put in writing and allow people to see what the practice of the staff is doing should look like, and how one who's involved in an enforcement investigation can expect to have the staff react to things, handle things, that sort of thing. So it's exactly as Nick said, it's not binding, it's not rules, but it is an important kind of signal of what the current leadership wants to see.
So I think the last enforcement manual was issued in 2017. Maybe, Lori, can summarize some of the key changes in this one.
Yes. Yeah. And so there are a number of changes that have received attention that are significant, and we can drill down on some of them. The first one that I would highlight is the Wells process. So basically when the staff has decided that there have been violations of the securities laws in the staff's view at the end of an investigation, they give potential respondents an opportunity to put feedback into the process, to give feedback on those findings. And that's called the Wells process. Giving notice to the potential respondent is a Wells notice, that sort of thing. This process has been really thought about and by Chairman Paul Atkins. He's spoken about it over the years prior to becoming the chairman of the commission. And Judge Ryan, in recent remarks, also talked about the Wells process. And this is something clearly the division is giving a lot of thought to, and that's reflected in the manual. So the manual now has a number of changes to the Wells process, that some of which are really just putting in writing practice that already existed, but kind of wasn't really formalized. For example, when someone got a Wells notice, you'd get 2 weeks to respond in writing. But everyone knew you couldn't actually meaningfully respond in 2 weeks, and almost no one provided a Wells response in 2 weeks. So now the manual has changed to say you have 4 weeks to respond. So it's recognizing that potential respondents need more time to respond to the staff giving them notice that their client may have committed some violation of the law. So that's like one example where I think practice really already was to go in that direction, but now it's documented. Another example is who is approving the staff giving a Wells notice. This is changed in the manual. Now the manual establishes the division director is giving approval for a Wells notice. And I think if that could be a significant change if the division director is expected to be deeply, deeply in the weeds on every single case in the division nationwide. That could slow things down, and that could be a more significant change. But it also could be just a codification or a writing of the practice, which is, in general, the staff is not making a finding and a recommendation that someone has violated the securities laws without awareness up the chain, including to the division director, that the investigation has gone that direction. So in general, the division directors in kind of more recent times have noticed that Wells submissions are going out. It may be negative implied notice, like they got an email, they don't respond, but they know constructively that it's happening. It may be more in-depth meetings, depending on the significance and size of the case. But now the division director will have to approve. So that is a change, and it's in writing.
Before we
Would be else for us, this would be Judge Ryan who would have to approve the issuance.
Yes. So that would be Judge Ryan who would be approving. And I think, and she does have, and the division does have deputy directors now, and the manual doesn't speak to the role of deputy directors in this particular area, but the deputy directors obviously would be important to her in helping her kind of sort through this if it is going to be the case that hands-on, eyes-on every recommendation will be part of this process. There's also interesting content around sharing the investigative file in the Wells process that's new, but Nick,
yeah, I wanted to, before we left the Wells issue, I remember back in Dodd-Frank that there was supposedly a requirement that once Wells notices were provided, there was a clock that started ticking. And it was like 180 days that something had to happen, which doesn't seem to actually happen. But what it did seem to do was push Wells discussions into a pre-Wells. So for those people who don't know, a Wells notice, oversimplifying a bit, is the staff saying, we think we have sufficient evidence to recommend that the commission bring an enforcement action. Tell us why we shouldn't make that recommendation to the commission. So does the revised enforcement manual talk at all or give any indication about these sort of pre-Wells discussions? Or is there anything that might be illuminating there?
So there is some discussion about white papers, and that white papers can be a helpful part of the process, and that one can still continue to engage in and send in white papers. So it does talk and does provide some content around that. So there's nothing in the manual that prevents, prohibits, or dissuades anyone from talking in advance of the actual formal wells notice going out.
Right.
So as a practitioner, Lori, let me follow up on that, because we would do white papers when the wells notice is a disclosure event historically to prevent that, but we would not always do them for an individual or even a public company. But now that the division director is going to be evaluating whether it is a wells notice and likely will have a memo from the staff, would you recommend to clients now to always do a white paper so that when the director is looking at whether a well should be issued, she sees both sides of the argument? It's a more balanced presentation.
So it's difficult to say whether to always do or not always to do, because I think it does depend on every case is different. I do think that a couple things this director has said, Director Judge Ryan has said, she said she does read and reads everything herself, and that everyone should expect that the senior staff has read everything coming in. So, and she has said that she expects the wells meeting and process to assume that everyone has read everything that has been submitted. So in the meeting part, she would like to hear from people about new information or about something that's a particular difference between how the staff views something and how the respondent views something. She doesn't want you to cover everything soup to nuts every time. And I say that because I think that impacts how you think about the white paper and the wells process. You don't want a white paper that then is going to be saying exactly what you say in a wells submission. You're going to want each piece to expound upon hopefully new or different aspects of the recommendation, I think, with this group of deciders. I think if the white paper will help with that process, if getting people to think about before a wells why this is an unwise action would help prevent them from wellsing, absolutely. A white paper still is helpful, is an important part of the process. Yeah. Because as you pointed out, the wells can itself trigger for some a disclosure obligation to investors. And if you can avoid having that happen because you think the staff has got it wrong and will go away, a white paper I still think is very effective. But you would want to consider the fact that you've submitted the white paper and what you do with the wells process if it does go into a wells.
And for people who might not be familiar, we've been using these terms, white paper and wells submission. What's the difference?
So essentially, the difference really is whether or not the respondent has received a wells notice, which is basically, has the staff called the lawyer for the respondent and said, we the staff believe that your client has violated these specific statutes with this conduct, and we are going to seek the following relief: injunction, penalties, disgorgement, etc., followed by a letter. And the letter will lay out basically what was said on the call. It's a pretty high level call and letter. It's not going to give all the facts of everything that happened in the investigation, but it is a formal call, then letter that documents that the staff has made this finding. That's a wells notice. And once you've received a wells notice, then responding to that is a wells submission. Prior to getting that notice, there's a lot of times when the staff engages with counsel or counsel engages with the staff to say, hey, I can see the direction that this is going in the course of the investigation. You've taken testimony of, officers of my client, or I can see the questions you're asking me in the investigation process for my client to produce more documents, etc. And I'd like to talk about why I think this may be going the wrong way. And then you can submit a writing on those points, and that could be a white paper. Also, the staff sometimes comes to counsel and before a wells and says, we think things are going this way, a certain way. We think that but we would like to hear from you on this topic, or we want to know if there's an off ramp, would you be willing to settle before a wells? And it could begin settlement conversations. And before you begin with settlement conversations, as the lawyer for your client, you may want to say, wait a minute, there isn't a settlement here to be had because there's no violation. You guys are wrong. Let me tell you why we think you're getting it wrong. And here's a white paper to that effect. So a couple things that's interesting, the white papers are talked about in the manual, but it does make clear that a white paper can be rejected if you characterize it as the settlement document or try to limit its use. So they are, discoverable documents. And it is interesting that they say that because so often white papers do come up in the context of kind of a settlement conversation.
Yeah. Yeah.
Lori, I know you, in your 15 years at the commission, you sat through and presided over a number of wells meetings. I remember a few times sitting across the table from you. How often does the wells process change the staff's mind? And do you think that'll change in either direction now that, director will be involved in the decision to issue the wells notice?
So it's interesting. I do think that the wells process does change, maybe not the staff's mind, but it changes senior staff's mind. And the audience often is senior staff. The audience from defense counsel's perspective often is senior staff who are coming into the investigation at the end, and particularly at the level of the division director or the now deputy directors. And in the end, the commission itself, wells submissions, the written wells submissions go to the commission. Also, and this is in the manual, it's in the new manual, the action memos, which is the means by which the staff communicates to the commission about the case at the end, those have to discuss the wells process, and they have to discuss why they have to respond to the wells and the arguments of the defendant raised or respondent raised in the wells. So in the wells process, the audience is probably not necessarily the staff, but is rather, senior staff and the commission themselves. And the wells can be very persuasive with those audiences. Now that the division director is going to be more, at some level more involved in approving a wells, it could mean that some of the conversations around what the defenses are happen at an earlier stage, and in some cases. And so there's more impact or ability to influence the senior staff at an earlier stage, pre-wells. Because once the decision has been made to wells, some of the thinking has already occurred. That actually could be a consequence here. But I do think that the wells process, even if the division director has signed off on it, is a helpful process because it allows you to inform the commission and to just provide more information to the division director that may not have been available at the time that they approved the wells. And so they could still take a different decision. That said, it's important to note that the division director is supervising the entire enforcement division and all of its staff, and will feel it is important to support the staff, as will the deputies. I mean, this is they were working together, they're part of a team, and there's going to be some loyalty and sense of need to support the staff during the wells process, even if ultimately they start to decide that their view of the case differs from the staff. There may be points where they want to communicate support of the staff along the way.
When you were at the commission, what were the most persuasive approaches in a wells submission? Was it arguing the facts, arguing the law, arguing policy? I mean, what usually impacted you in terms of changing your mind on a particular case?
So it's interesting. I think to me, what was most impactful was when counsel came in and basically would acknowledge what was in the staff's favor. Like, why are we here? Like, okay, look, there are these things that, happened. And I understand that you staff may view this evidence or the law this way. And then said, but let me tell you why, these facts and or the law doesn't get to the place that you've gotten to. So a balanced approach, like acknowledging the strengths. There's a reason why the staff has issued the wells, like something has happened and there's some circumstantial evidence or some other basis to be in the room, and then provide kind of thoughts that are helpful out, either factual or legal, that the staff might actually not have considered. So are there witnesses they didn't talk to? Is there an expert report that could be helpful here? I did find expert reports and expert advice to be helpful, because the staff is a little bit in a vacuum. They're, lawyers and accountants, and now there are industry experts at some levels of the staff who are brought in. But at the end of the day, I will speak for myself. I went to the staff as a fairly young third-year lawyer out of a law firm. I had not worked for a company. I had not worked for an advisor. I had not worked for a law firm for very long. So, even after a number of years, you still are seeing things through the prism of having worked in the government. And so experts or outside thoughts, perspective, industry perspective can be a helpful, not absolute, but a helpful guide to give people if presented as part of a balanced presentation.
Yeah.
And it's interesting because the enforcement manual, actually, the new edition, some of the changes reflect this exactly. Like, so one of the interesting things that they changed was to say, here's what's helpful in a well submission. And they use the word helpful. And then they give a number of examples. And some of the examples are things we've been talking about, like being balanced in your acknowledging that, where the law or the facts are not in your favor, but also responding to areas that you and the staff may have disagreements on, and really focusing on those areas and not just covering soup to nuts every possible thing you could argue. And then they actually add a thing noting that expert reports, if on a complex area of law, can be helpful, which I think it was an interesting addition to the enforcement manual.
Yeah. Well, I sent us back down the wells rabbit hole just as you were about to turn to another aspect of the revised enforcement manual. So I know we want to talk about some of the other things there too.
Yeah, this was actually, I was going to say that part of the wells process that has gotten a lot of attention, and then we can move on from wellsing, is sharing the investigative file. And that's something that a lot of practitioners have really been talking about, because there's been across the division in different offices a wide range of practice related to whether the staff shares information that it gathered in its investigation from others outside your client, and what they share and how much, do they share all the testimony transcripts, some of the testimony transcripts, none of the testimony transcripts? Do they share some of the, maybe they obtained financial records or phone records or brokerage records? Do they share content, work product, etc., that indicates how they're using that material to influence their recommendation? Do they give you a reverse proffer of their thinking about the recommendation or not? So it's interesting that in the enforcement manual, there is an addition saying, I would say encouraging sharing the investigative file. The staff is instructed to be forthcoming about its content without sharing confidential information. So that's a good change. So I think another significant change that people should be thinking about as practitioners is the portion of the manual talking about cooperation credit. So the question of whether to cooperate and what cooperation means is always a hot topic. It's hard for practitioners to get a clear handle on it, and it's often hard for clients to really value cooperation or know what value to give to cooperation. And it's interesting, the manual has leaned into providing more content around what this Division of Enforcement and this commission want to see and think will be helpful in cooperation credit. So there's some content there that we can talk about. And then there's also a carrot, which is they do explicitly put into the manual a discussion about civil money penalties and whether or not civil money penalties will, and the fact that civil money penalties can be impacted by significant cooperation, including findings that there will be no penalty against an entity if they cooperate. And of course, it has been the case for many, many years that if an entity cooperated fulsomely, the staff has agreed to and the commission has issued settlements with no monetary penalty. So that is a practice point that has always been available, but it's interesting that it's actually put in the manual in writing for defense counsel and the staff to see, so that everyone can be kind of on the same page talking about, okay, I go to my client and I can say, company, there is a value to cooperating at the beginning of this here. And they give specific examples of steps that for both remediation and cooperation that they think should be seen. And those can be taken to a client. And then the portion that says civil money penalties can be affected by cooperation can be shown to clients. And so it helps kind of put something out there around this topic of cooperation, which has always been hard because it's hard to know how much value to give cooperation and what exactly constitutes cooperation.
Yeah, it seems like there's always that moment where there's a gap of trust. We have some negative information that we, in a fully cooperative mode, would share with the staff, but we don't trust, rightly or wrongly, we don't trust that handing over this adverse information will result in a quantifiable benefit to us. And it seems like the revised enforcement manual is trying to fill that gap.
Trying to. I mean, it's not clear yet, like whether it will get there, but it does open the door for that, to try to fill the gap of trust. I mean, it does talk about the division can recommend to the commission that no penalty be sought at all for a cooperating entity. And so, or that a reduced penalty can be sought. And so that is a helpful way to talk about it.
Yeah.
The manual also adds more transparency and discussion around the cooperation committee. So in the division, there's a cooperation program that is overseen by a cooperation committee, and the manual talks about the cooperation committee being involved in decisions around cooperation, including for individuals now, switching a little bit, like deferred prosecution, non-prosecution agreements, and things like that. And so perhaps that's another way that the division is thinking about trying to say to respondents and companies, we have a process that's outside the staff or in addition to the staff that's working on this matter, who can think about whether your cooperation leads to a particular outcome.
Yeah. Right.
We'll see.
Yeah.
Well, these are all tremendous insights. Lori, any more insights about the new enforcement manual?
So I would tick off a couple small things that I think are interesting and helpful. One is termination letters. So a lot of times we represent parties that get requests for documents. They're not part of this happens in insider trading cases a lot. Frankly, entities get hit with pretty burdensome, sometimes subpoenas for documents related to some individuals' insider trading. Company's not on the hook. Company's not going to be liable. Company had all the proper policies and procedures in place, but they spent a lot of money on this and they would like to know when the investigation ends, and they would like to, and this can help with preservation of document obligations and the like. Yeah. So now the manual has added a provision in the termination letter section saying entities who provide documents but were not kind of a subject should also receive a termination letter. And I just think that's helpful for clients to realize.
Yeah.
So that's one. And then the last one I would add is I would change back to the process that used to exist of considering settlements and waiver requests at the same time. And this can be particularly important for publicly traded companies and regulated entities who want to settle with the commission and need to get waivers of certain automatic statutory disqualification provisions, like the well-known seasoned issuer, the bad boy provisions of 506. There are things that come up that are automatic statutory disqualifications. A waiver needs to be in place. For regulated entities, it can be disqualification from, continuing to go forward as an investment advisor or a broker dealer. So these are serious. Now the waiver that needs to accompany a settlement can be considered at the same time as the settlement. And that just gives more certainty to the settlement process and more efficiency around the settlement process. So it's good that that's in the manual. It had been prior practice a few years ago, but it goes back and forth. The waivers had become somewhat of a political football over the years. And so it's good to see that it's back.
I noted that the new manual says that it will be revised, I think, annually.
Yes, it does say that.
So this waiver and settlement discussion thing could, swing back the other way in a few years. But
Absolutely.
For now,
I do think it makes it more of a bellwether of what the current division and commission want to see from the staff in the practice of investigations. And so if they actually update it annually, it would become more of that signal, I think.
Yeah, more useful, really.
More useful, actually. Yeah.
Well, Lori, this has been tremendous. When Nick and I invited you, we knew it would be an excellent discussion, and this far exceeded our expectations. So thanks.
Thank you.
Thanks for all your insights on the new manual and how it's going to affect SEC enforcement.
Absolutely.
Thank you very much for joining us. And we look forward to having you join us again in the future on another topic like this. Nick, always a pleasure to see you. We'll see you in the next Roundup.
Yep.
Until then, thank you very much.
Thanks, everyone.